Evading arrest. What does that mean? What if you didn't do anything wrong? Is there a way to be able to get your case dismissed? Hi, I'm Jeff Hampton with the Hampton Law Firm. Today I want to talk to you about the subject of evading arrest. What does Texas criminal law require the prosecutor to prove in order to convict you? And is there a way to defend this to protect your freedom and your future? By the way, if you wait around to the end of this video, I'll give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Now, listen, here's the problem that comes up on this evading arrest situation. What if you've done nothing wrong? What if you are being wrongfully and illegally targeted by law enforcement, asked to participate in a particular type of investigation, or maybe you feel like they're singling you out? I want to remind you of something. The absolute worst thing to do is the thing that you'll be tempted to want to do because you'll be mad at the police. Your temptation will be to try to either walk away or run away from the police. Okay, but I want to remind you, if you do that, you're almost making it easy for the police to claim that you are evading arrest or detention. You say, well, I wasn't under arrest. Sometimes police officers will want to claim you were being detained for an investigation. That will then give them the opportunity to potentially arrest you for evading arrest, even though you didn't do anything wrong. Now, making the decision to run can result in a chase on foot or on vehicle, creating an increased risk. Here's the other problem. What if you run and now it creates some type of risk of serious bodily injury or death to someone else, or an issue with the public? This is the whole reason why the Texas legislature has included evading arrest as a serious crime. So serious, in fact, that it's possible to get a prison sentence, depending upon your circumstances, of up to 20 years. Okay, so let's talk about this. Under Texas Penal Code, section 38.04, let's see how the state of Texas defines the crime of evading arrest. The state of Texas, through the district attorney's office, will be required to prove the following elements beyond a reasonable doubt. Here's what it says. A person commits the offense of evading arrest if he intentionally flees from a person he knows is a peace officer attempting lawfully to arrest or detain him. Now, there's some real key words there that I would want you to hone in on here in a minute. Number one is intentionally. That's a good word to hone in on. And then the other one is that he knows is a police officer, and that whether or not there was a lawful arrest. So we're going to look at that here in just a minute, okay? So if a police officer is attempting to execute a search warrant on your residence, here's what tends to happen. Some people say, I'm not letting you in. I don't believe you. I don't like this. This is illegal. It's based on false information. The problem is, if you don't cooperate with that process of what's going on, or you try to get away from that process, they can use your lack of cooperation in that process as a claim that you're evading arrest. Now, the reality of it is Texas law imposes upon every person in its jurisdiction the responsibility of submitting to a police officer, that the authority of a police officer that is attempting to lawfully arrest or detain someone, as long as it's lawful, right? As long as they're acting within the scope of the law. Now, what is the punishment? Let's talk about this before we get into the defenses. People ask all the time, what's the punishment, and what is the punishment range for being charged with evading arrest? Well, the biggest issue comes down to this. Did you run on foot or did you run by vehicle? If you evaded arrest on foot, it is a misdemeanor offense. If you evaded arrest in a vehicle, it is a felony offense. Now, let me break that down just a little bit more. Under Texas criminal law, you have a Class A misdemeanor for evading arrest, punishable by a term in the county jail of up to 1 year and up to a $4,000 fine if the evading arrest did not involve the use of a motor vehicle and the citizen has been previously convicted of evading arrest. Now, if you've never been convicted, what if it's your first offense? What if you're a first-time offender? You're looking at a Class B misdemeanor of evading arrest by foot, on foot, okay? That's punishable by up to 180 days in jail and up to a $2,000 fine. Now, you could be looking at a state jail felony, punishable by up to 2 years in a state jail facility and up to a $10,000 fine if the citizen has been previously convicted of evading arrest. And you're looking at a third-degree felony, punishable by a minimum of 2 up to 10 years in prison and up to a $10,000 fine if the vehicle was used by the citizen during the arrest. So remember I talked about if you have a vehicle. If you're using a car, if you're using a vehicle and you're evading, get into a high-speed chase or you're running from the police in some way, you could be talking about a felony offense, and then you could be talking about even more serious charges if someone ends up being seriously injured, if you end up having an injury in the process of all that, okay? So now what if someone dies or is seriously injured as a result of the evading arrest in that vehicle? Now you could be talking about a second-degree felony punishable by up to 20 years in prison and up to a $10,000 fine. Now let's talk for a few minutes here. Listen, anybody that hires an attorney facing an evading arrest charge wants a few things to happen. The number one goal at the Hampton Law Firm, if you were to work with us here, is to number one, help you stay out of jail. No one wants to receive a jail sentence. No one wants to have lose their freedom in any way for a criminal charge. That's number one. Number two is we don't want you to have a conviction. Your attorney should work tirelessly to try to resolve your case in a way that does not result in either a misdemeanor or felony conviction. Why? Because that leads to number three. The number three goal is to resolve the case in a manner that allows you to get it off of your criminal record. And that can be done by an expunction or a non-disclosure. Either way, particularly if you're a first-time offender, you must work with an attorney that has the experience to both get cases like this as an evading arrest dismissed and has the knowledge of how to make sure and help you get it off of your criminal record. Now let's talk for a couple of moments before we finish here about defenses. What are your legal defenses to an evading arrest? Well, the first one we've already kind of articulated for a moment, which was the arrest lawful? Okay, this is a critical issue that must be explored in all evading arrest cases, is whether or not the actions of the police officer were lawful in detaining or arresting you. If the police officer made the decision to arrest or detain without a valid warrant, or made the decision based upon a lack of reasonable suspicion to pull over your vehicle or to engage in some type of investigation of you, then your evading arrest charges may be thrown out by a judge. In fact, your attorney can file what's called a motion to suppress. With that motion to suppress, your attorney can request a hearing where the judge gets an opportunity to see whether or not these actions were lawful or not. And let's say your attorney does a great job on that and the facts are on your side, the judge could then throw out the entire case based upon that arrest being unlawful. All right. Now, number two, can the state of Texas prove criminal intent? You've got to remember that the prosecutor must prove beyond a reasonable doubt that you intentionally or knowingly fled from a person you knew to be a police officer attempting to lawfully arrest or detain you. What if you didn't know the person trying to arrest or detain you was a police officer at all? What if you didn't know that they were actually trying to detain or arrest you? One of the best examples I can think of on this is we represented a client who an undercover plainclothes police officer approached him in a bar because basically the bar thought he was being too rowdy and they wanted him to get out of there, except they just went and got one of the police officers that was outside in plain clothes, told him to come in and get this guy out of there. So of course what he does, the officer reaches over to the client, begins to try to pull him away, because he couldn't hear, the music was really loud, begins to try to pull him away from the bar. In the process, the officer, of course, our client is like, I don't know who this guy is. He pulls away and starts trying to get away from him. The officer pulls him down to the ground and proceeds to arrest him and claim that he was evading arrest and detention. Now, did the client actually know that that person was a police officer when he's in plain clothes? What if there was loud music playing at the bar, which of course there was? What if the client couldn't hear when the officer was trying to tell him because all he could see was this guy just in regular clothes? He thought he was just a patron at the bar. So the reality of it is, our argument was that our client was acting reasonable when he thought there was this crazy guy trying to pull him away from the bar and he didn't know that he was a cop. So as a result of that, that showed that our client did not act with the criminal intent necessary to evade or even resist arrest in this set of circumstances. Another example of the defense of criminal intent, or the lack of it, is a situation where someone is driving down the road, and we've had many of these. They're driving down the road and something is impeding their view from behind them. We represented a guy who was kind of in a work truck and it was stacked full of stuff in the back in the crew cab, and as he was driving, the officer turned on his lights to pull him over. But our guy just kept driving at the same rate, went multiple blocks, didn't pull over, because he never saw the lights and he had his music turned up. He never heard it. He never heard the siren that was going on behind him. Then when he finally did realize it was a police officer, he pulls over, right? Well, in the meantime, he's been driving 4 or 5 blocks, and what do you think the police did? The police come out, guns raised up, saying, "What's wrong with you? How dare you evade arrest?" Immediately arrest him for a felony evading arrest charge. Can the prosecutor really prove the element of criminal intent there? Our argument was absolutely not. If our client wanted to really get away from this officer, the best way of proving that intent is him on a high-speed chase, driving down the road, doing everything he can to get away, and that's exactly not what happened. Our client instead was driving at the same speed, minding his own business. And so it's so very important in each situation that it's examined. And one of the best things you can do as your attorney, like we did in this situation, if you're facing a felony evading arrest, we're able to provide that information to a grand jury to possibly get rid of your case very quickly. And please understand, if you're facing an evading arrest with a vehicle, which is a felony charge, if your set of facts has a valid defense, your attorney may be able to make a presentation to the grand jury. And remember, a grand jury is a panel of citizens that meet to determine if a case has probable cause to move forward as a felony. And they've got a couple of choices. They can keep your case as a felony, that's number one. They could lower your charge down to a lesser misdemeanor charge, that's number two. Or they could no-bill your case. And a no-bill is the equivalent of you being exonerated of all charges. And that's exactly what your attorney needs to do. Now, I'm going to warn you about this, though. You need to make sure you're working with a lawyer willing to put together an evidence packet early in the process. If your attorney does not act aggressively on this, the problem is that grand jury is only going to hear one side of the story, and it's not yours. It's the prosecutor's. And as a result of that, your case will be rubber stamped as approved as a felony, and now you're going to have to go through the long process of negotiations. Okay? So I want you to understand, if you are facing an evading arrest charge, whether it's a misdemeanor or a felony in the North Texas area, maybe you're out of the Fort Worth or the Dallas area, we want to offer you a free consultation and a free case analysis. So don't hesitate to contact the Hampton Law Firm. Now, I promised you if you waited around to the end of this video, I'd also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. All you have to do is click the link right down below. I'll be happy to send that right over to you, and it'll give you some free information. And listen, I hope you liked what you heard today. Subscribe to our YouTube channel, like our video series, and we'll send you more great content. Look forward to seeing you in our next video.